All right, today we're jumping into a huge court case that basically set the stage for your digital privacy rights way, way before smartphones were even a thing. It's a fascinating story that starts with an anonymous tip and ends with a legal debate that we're still having today. So let's get right to it with a question that's at the very heart of this case. What can your utility bill actually say about you? And maybe more importantly, who should be allowed to take a peek at it? This exact question is what kicked off the whole thing. So, picture this. It's March 1990 in Calgary. The police get a call on their anonymous Crime Stoppers line, and the tipster says there's a marijuana grow-up happening in the basement of a house on a certain street. Now, this is the best part. The person who called didn't have the address, not even a house number. All they had was this one kind of random detail. But believe it or not, that was enough. An officer just drove down the block, spotted the house that matched the description, and bam, the investigation was on. Okay, so acting on that tip, the police make two big moves. And here's the absolute kicker. They did both of them without getting a warrant. And this breaks it down perfectly. First, you have the physical search. Officers literally just walked onto the guy's property and noticed some suspicious stuff, right? Covered windows, a plugged-up dryer vent. Then there's the digital search. An officer sat down at a police computer, logged into the city's utility records, and discovered the house was sucking up 4 times the normal amount of power. So you put it all together, the anonymous tip, what they saw at the house, and that crazy high electricity bill. Well, now the police had enough to finally get a proper search warrant. They went inside, found 112 marijuana plants, and arrested the guy living there, Robert Plant. But that arrest was just the beginning of a huge legal fight that went all the way up to the Supreme Court of Canada. And this all boils down to one massive question for the court. Did the police cross the line? By walking onto his property and digging through his power records without a warrant, did they violate one of the most basic rights we have in Canada? So how did the court tackle this? Well, they were pretty smart about it. They didn't just lump all the police actions together. Instead, they split them up and looked at each search on its own. And what they decided would change Canadian law forever. Okay, first, the easy call. Every single judge agreed that the police walking onto the property for a look-see, that perimeter search, was totally unreasonable. I mean, it's a physical trespass, plain and simple. So yeah, that was a clear violation of Plant's rights. But then, and this is where it gets really wild, a majority of the judges decided that the computer search of the electricity records was reasonable. They said it was totally fine for the police to do that without a warrant. So, wait a minute. How does that work? Why is walking around the outside of a house a major privacy violation, but looking up its energy data is perfectly okay? Well, it's because the court came up with a brand new legal test, right here in this case. They created this idea called the biographical core of personal information. Basically, they said that for something to be legally private, it has to reveal intimate, personal details about your lifestyle and your choices. And in their view, how much electricity you use, it just didn't cut it. And this quote from the majority opinion really says it all. They basically saw it as just commercial data. It wasn't a diary, it wasn't a private conversation, it was just a number. And that one distinction was everything. But, and this is a huge but, not everybody on the court saw it that way. One judge, Justice McLaughlin, who would go on to be Chief Justice, wrote this incredibly powerful disagreement. She thought the majority got it totally wrong on the computer search, and her reasoning was, looking back, way ahead of its time. Yeah, and this is where you really see the two different visions for the future clash. On one side, the majority says, it's just commercial data, nothing personal here. But on the other, Justice McLaughlin is saying, hold on, computer records can tell you a lot about what's going on inside someone's home. And she made a killer point. The police needed a special password to get that info. It wasn't just lying around for anyone to see. I mean, listen to this quote. She was basically predicting the future, arguing that our digital lives deserve the same privacy protection as our physical homes. She saw that computers were going to become treasure troves of personal information, and she believed the law needed to protect that. So at the end of the day, Robert Plant was convicted. But the real story here is so much bigger than that. Why should you care about a 30-year-old case about a grow-up, especially now, in our world of social media and smartphones? Well, it's because this test they created, the biographical core, is still the rulebook. It's the fundamental standard our courts use to figure out your privacy rights in the digital world. Every time a new piece of tech comes along, judges look back to this case to decide if the data it creates is personal enough to be protected. So what kinds of things count today? Well, following the logic from Plant, the courts have now said that all of this stuff is part of your biographical core. Your texts, where you've been, what you search for online, your private messages, your emails, all of it is now considered deeply intimate and protected from unreasonable searches. And that leaves us with the massive question we are all still trying to answer. As technology gets more and more woven into our lives, what information is truly personal? What reveals our biographical core? And where do we as a society draw that line? It's a debate that's constantly changing, and to think it all started with an anonymous tip about a cute house in Calgary.